She doesn't have a head for these things. That's what my wife said. Not quietly. Not as something she meant only for her attorney's ears. She said it across a conference table in downtown Roanoke on a Tuesday morning in March, loud enough for the mediator to hear it clearly. Loud enough that her brother, sitting to her right, nodded as if she had just confirmed something everyone already knew. The mediator, a woman named Louise Farrand, had been appointed by the probate court to oversee the settlement of my mother-in-law's estate. She was somewhere in her mid-60s, silver-framed glasses, a legal pad open in front of her with several pages already covered in notes. She didn't react to my wife's comment right away. She finished writing a sentence, capped her pen, and looked at me briefly before turning to the attorney across the table. "Counselor," she said, "before we continue, I want to confirm something for the record. Can you describe your client's husband's professional history?" My wife's attorney, a man named Craig Beal, who had been introduced to me with the particular confidence of someone who had never once been wrong, cleared his throat. "He's retired, formerly in insurance." "What aspect of insurance?" "Administrative, general management, as I understand it." Louise Farrand's expression didn't change. "General management," she repeated. She wrote something on her pad. Then she looked at me. I said nothing. I had learned a long time ago that the most important thing you can do when someone is describing you incorrectly is give them enough room to finish. "My name is Fletcher Dowd. I'm 61 years old. I spent 31 years investigating insurance fraud, first for 2 regional carriers in Ohio, then independently, as a consultant retained by firms that needed someone to look carefully at things other people had stopped examining. I have a degree in accounting and a second in forensic financial analysis I earned at night school while working full-time. I have testified as an expert witness in 29 civil proceedings and 8 criminal trials. I have identified forged signatures on documents that 3 other investigators certified as clean. I have reconstructed financial timelines from records other people considered too incomplete to be useful." My wife knew this the way she knew my blood type, as background detail, not a fact worth considering. We had been married for 30 years. We had 2 children, a son who was 28 and lived in Denver, and a daughter who was 32 and had moved to Portland 4 years earlier after a disagreement with her mother she had never fully explained to me. Both of them had been notified before the mediation. My son sent a text the evening before. "Mom says this is about protecting the estate. I'm sure it'll get sorted out." My daughter hadn't reached out at all. My mother-in-law died 11 months before that Tuesday in Roanoke. She was 79. She had worked as a school librarian for 34 years in the same district in Carroll County, Virginia, retired on a modest pension, and spent the last decade managing what she had accumulated with the same methodical care she brought to cataloging books, systematic, patient, deliberate about what she kept and why. She had a paid-off house in Galax, 2 investment accounts she had built herself across 4 decades, and a small rental property that had appreciated considerably since she purchased it in the early 1990s. By most measures, she was not wealthy, but she had been consistent, and consistency over 40 years builds something real. When her hip fracture required surgery and a long recovery, my wife volunteered to help. She drove to Galax twice a week, sometimes 3 times. She sat with my mother-in-law during physical therapy appointments. She helped sort the mail and manage correspondence with her financial institutions. My mother-in-law was grateful in the direct, undemonstrative way of women her generation. She didn't say thank you more than once for any single thing, but she said it deliberately when she did. 3 weeks into the recovery, my wife brought paperwork. I didn't know the full extent of what was signed. My wife mentioned a limited financial power of attorney, something to handle bills while her mother was immobile. I didn't press for details because I had no reason to. My mother-in-law trusted my wife. I trusted my mother-in-law's judgment, and my wife, to her credit, managed the logistics efficiently and without visible complaint, which I took as evidence of good faith rather than motive. My mother-in-law died on a Thursday in early spring, 8 months after the surgery. I was not with her when it happened. My wife was. She called me from the hospital, her voice composed in a way I noticed but didn't examine closely enough. The drive to Galax took 2 hours. I spent most of it remembering small things, the way she pronounced certain words, the way she kept every Christmas card she had ever received in a shoebox she could describe the entire contents of without looking. The petition arrived 6 weeks later. I found it in the mailbox on a Monday morning, tucked between a utility bill and a seed catalog. I sat in the driveway and read it in the car. It was a petition to the probate court requesting that my wife be named sole executor of her mother's estate, with full discretionary authority over asset management and distribution. It cited my emotional unavailability since my mother-in-law's death. It noted my lack of involvement in financial planning during the recovery period. It described my retirement as evidence of reduced engagement with financial affairs and included a letter from my wife's physician, not my physician, my wife's, noting that she had reported concerns about her husband's capacity for clear decision-making during periods of grief. I read it 3 times. The language was careful in the way that language is careful when someone has spent time making it so. Nothing accused me directly. Everything implied. Emotionally compromised since bereavement. Historically disengaged from household financial management. Unable to distinguish sentimental attachment from sound judgment. I set it on the passenger seat and looked at the house for a while. There is a particular feeling that arrives when something you have been watching from a distance finally comes into focus. Not surprise, something closer to recognition. I had spent 31 years learning to name that feeling in other people's files. I had never expected to find it named in my own drive. I went inside, sat at the kitchen table, and did not think about anger. I thought about sequence, what had happened, in what order, and what that order meant. Then I walked to the study and checked the P.O. box key I kept in the back of my desk drawer. I had maintained that P.O. box since my consulting days, a habit from years of work that sometimes required separation between my private address and case materials. My wife knew about it in the abstract. She didn't know the box number or where the key was kept. That had never seemed significant to either of us. In the box was an envelope I had not expected. It had been mailed from Galax 6 days before my mother-in-law died. The return address was her house. My name was written on the front in her handwriting, careful, deliberate, slightly uneven in the way it had become in her last year. I sat in the post office parking lot and held it without opening it for a long while. Inside was a letter, 2.5 pages, written on the same white notepaper she used for grocery lists. Tucked inside the letter, in a small paper sleeve she had made from folded tape and cardstock, was a flash drive. Her handwriting was slower than I remembered. Each word formed with the effort of someone who had something important to say and was not certain how much time remained to say it. She wrote that she had trusted my wife and that in the months since the surgery, she had begun to doubt whether that trust had been warranted. She described specific transactions she hadn't understood, transfers to an account she didn't recognize, documents she had signed when she was still on post-surgical pain management that she later couldn't remember clearly. She wrote that she had asked my wife about them and had not been satisfied with the answers given. She wrote that she had said nothing to anyone else because she didn't want to cause a problem that might have a simple explanation. But she had made recordings on her phone during some visits. Virginia, she had looked it up herself, allowed one-party consent recording, and she had kept them, just in case. She wrote that she was sending this to my box because she knew I was the one who paid attention to things that other people waved past. She wrote, "You always noticed what the rest of them were too busy to see. I need you to look now." I sat in that parking lot for a long time. When I finally drove home, I didn't go inside immediately. I sat in the driveway where I had read the petition and let the full shape of what I was holding settle around me. Then I called an attorney named Harriet Cole. I had worked alongside Harriet for 11 years on insurance fraud cases before she moved to private practice. She operated out of a small office in Charlottesville and was exactly the kind of person you want when the other side has built something they believe is airtight. She listened without interrupting. When I finished, she was quiet for a moment. "They assumed the petition would go unopposed," she said. "People who build these cases usually do. They expect the grief to do the work for them." "It nearly did," I said. "What do you want from this?" I thought about my mother-in-law's handwriting, about 31 years of looking at documents that told one story in the open and another story in the margins. "I want the record to be accurate," I said, without making a scene. "Then we document and let the process surface it," she said. "Can you give me 2 weeks?" I told her I could. Over those 2 weeks, I lived inside the frame my wife had constructed. I answered her questions in short sentences. I let her believe I was still managing grief and nothing more. She reviewed some preliminary financial disclosures from across the kitchen table one evening, and I watched her shoulders ease, and I noted it without comment. People who believe they have already won stop looking closely. That is not a flaw in human nature. It is a pattern, and patterns are information. Harriet worked methodically. She pulled financial records from the institutions associated with my mother-in-law's accounts. The power of attorney, when she obtained a full copy, was substantially broader than anything I had been told. It granted my wife authority over all accounts, all property transactions, and all estate decisions, effective immediately upon signing. My mother-in-law had signed it 14 days post-surgery during the period her discharge paperwork listed as requiring managed analgesic protocol. Harriet located the prescribing records. She located the pharmacy fill logs. She found a neighbor who had lived 2 doors down in Galax and had been close to my mother-in-law for 20 years. A retired teacher who had noticed my wife arriving on a specific Saturday with a folder under her arm, on a day my mother-in-law had told her she wasn't feeling well enough for company. She also identified the routing. Several significant transfers from my mother-in-law's investment account had passed through a small financial services firm in Roanoke, a one-woman operation that was not licensed for estate management and whose transaction records, when requested under proper legal authority, were thin in a way that suggested deliberateness. The woman who ran that firm retained counsel within 48 hours of being contacted by Harriet's office. That was, as Harriet put it when she called to tell me, a useful development. I drove to Galax the night before the mediation. Not to go inside my mother-in-law's house. It was still part of the estate, the doors locked the way she had left them, but to park across the street and sit for a while. The porch light was on automatic. She had set it that way years ago, and no one had changed it. It came on at dusk and went off at midnight, the same as it had the entire time she'd lived there. I sat in the car and thought about the letter, about the flash drive and what Harriet had found on it. My wife's voice, clear and unhurried, discussing account movements during a visit on a day my mother-in-law had been unwell. I thought about 31 years of looking at documents that people believed no one would examine closely. I thought about the way my mother-in-law had squeezed my hand at our wedding reception, briefly, firmly, the way you hold someone's hand when you mean it, and told me I was a good reader of people, and that was rarer than I thought. The following morning, when my wife stated to the mediator that I was a man who couldn't manage a grocery list, I stayed still. I had learned that stillness is not absence. I had learned it from cases where the truth was already in the file, and the only thing remaining was to wait for the right question. Louise Farrand asked her question. Harriet rose without urgency. She placed her briefcase on the table, opened it, and addressed the mediator in the even tone of someone who has nothing to prove. The petition before you rests on the claim that my client lacks the standing to participate meaningfully in the settlement of his mother-in-law's estate, she said. What we intend to demonstrate is that the estate was managed responsibly for decades by the woman who built it, that the material changes to her financial arrangements occurred during a period of documented medical vulnerability, and that my client not only identified those irregularities, but documented them through means the court will find highly relevant. She began with the timeline. Account statements appeared on the monitor at the end of the table. 38 years of consistent, unspectacular financial behavior, followed by a pronounced shift in activity beginning 2 weeks after the surgery. New transfers. New account designation. Several transactions whose listed purposes did not correspond to any documented expense or service. Craig Beale objected. Louise Farrand overruled him before he finished the sentence. Harriet moved to the power of attorney. She did not characterize it. She placed it beside the medical record of the day it was signed, and beside the discharge protocol specifying pain management requirements during that recovery window. She let the dates speak for themselves. She presented the recordings. Not all of them, 3 excerpts each under 90 seconds. We had chosen them together the night before, the same way I chose evidence in every case I had worked, by asking what a reasonable person would understand without being told what to understand. The room was quiet while Louise Farrand listened to the 3rd recording. My wife's hands were flat on the table in front of her. Her brother was looking at the wall. Then Harriet said, "I'd like to offer some context about my client's professional background." Louise Farrand nodded once. Harriet looked at me. I stood. "I spent 31 years in insurance fraud investigation," I said. "First with 2 regional carriers, then as an independent consultant. My work involved identifying irregular financial transactions, improperly executed documents, and patterns of undue influence in estate and insurance cases. I have served as an expert witness in 29 civil proceedings." Louise Farrand looked at me for a moment. Then she looked at Craig Beale. "Counselor," she said, "was this background included in your client's assessment of her husband's capacity?" Craig Beale's jaw moved slightly before he spoke. "We understood his background to be in general insurance management." "General management," Louise Farrand repeated. She wrote something on her pad. My wife stood up. I recognized the particular straightness that came when she felt the room shifting. "He's been retired for 4 years," she said. "He sits in that house and reads. He doesn't engage with anything real. He never once asked to see my mother's accounts, not once in 11 years. She looked at me then. The first time that morning, she had looked directly at me. "You've always been somewhere else, even when you were in the room." Louise Farrand raised one hand. "Mrs. Dowd, please sit down." My wife sat. Her brother said nothing. His hands were folded on the table, and he did not look up. Harriet continued without acknowledging the interruption. She placed my mother-in-law's letter before the mediator. She did not read it in full. She noted its existence, its postmark, the circumstances of its preservation, and the fact that the flash drive it contained was the source of the audio recordings already entered. Then she read 2 sentences aloud. We had chosen those sentences together the evening before. Louise Farrand read the full letter herself without rushing. When she set it down, she folded her hands and looked at the table for a moment before looking at me. "Mr. Dowd," she said, "you've been largely quiet this morning. I want to ask you one direct question. Did you have knowledge of the financial irregularities in your mother-in-law's accounts before your wife filed this petition?" "I had a general sense that something was wrong," I said. "I didn't have documentation. The petition gave me the reason to find it." She nodded slowly. "So in effect, the petition accelerated your investigation?" "Yes," I said. Louise Farrand was quiet for a moment. "Then I'm dismissing this petition with prejudice." She set her pen down. "Based on the documentation presented, and the inquiries now formally on record, I'm also referring this matter to the Commonwealth's attorney for Roanoke County and to Adult Protective Services for review under the applicable financial exploitation statutes. The financial institutions identified in these records will receive formal notification." My wife's head lowered, not in shame, but in the particular way of someone recalculating everything that happens next. Her brother said nothing. He was still looking at the table. Outside, Harriet walked with me to the elevator. She said what she always said after proceedings she believed in. "This part is finished. The rest takes longer." I told her I was familiar with longer. The consequences came in sequence, the way they do in serious cases. The Commonwealth's Attorney's Office opened a formal investigation within the week. The financial institutions cooperated once the paperwork was in order, and Harriet's paperwork was always in order. The full transaction audit covered 14 months. What it found was not surprising to me. Transfers routed through the unlicensed firm and listed as estate administrative fees. Withdrawals timed to coincide with dates on which my mother-in-law's medical records reflected high-dosage adjustment periods. And one transfer, significant in the context of a librarian's lifetime of savings, to an account in my wife's name opened 9 months before her mother's death. My wife did not come home the evening of the mediation. She sent a message from her sister's house, brief and blunt. "You humiliated this entire family. I hope you're satisfied." I read it once and set my phone face down on the kitchen table. My son called the following morning. His voice was careful in a way it hadn't been in the text he'd sent the night before. His mother had told him I had orchestrated everything as retaliation. He said he didn't know what to believe. I told him I wasn't asking him to believe anything. The case filings would become part of the public record with the county clerk once the investigation was formalized, and he could read them and draw his own conclusions. He was quiet for a moment. "She always said you were checked out," he said, "that you were physically there but never really present." "I know she did," I said. "Were you?" I thought about 31 years of finding things in documents that other people had certified as clean. I thought about that parking lot in Galax, and the envelope, and the letter inside it. "I was paying attention," I said. "I just didn't announce it." He didn't respond immediately then. "I don't know how to hold all of this at once." "You don't have to," I said. "Take whatever time you need. I'm not going anywhere." My daughter called 4 days later. She had seen the public filing through the county's online records portal. Her voice was steadier than her brother's, which made sense to me once I thought about it. She had always processed facts before feelings. "There's something I should have said at the funeral," she told me. "Grandma's emerald brooch, the small oval one she wore for every holiday. Mom had it on at the reception. She told me Grandma had given it to her before she died." A pause. "I knew Grandma would never have given that brooch away. She told me years ago she wanted it kept in the family, passed down." I didn't say anything because I didn't want to fight at a funeral. "You couldn't have known it was part of something larger," I said. "I knew it felt wrong," she said. "I should have trusted that." She was quiet for a moment. "Then do you think she knew, Grandma? Do you think she understood what was happening?" I thought about the letter, about the fact that my mother-in-law had looked up Virginia's recording consent law on her own, on a phone she was still learning to use, because she wanted to be certain the recordings would hold. About the flash drive in the paper sleeve she had made with tape, about the postmark on the envelope. "She knew something was wrong," I said. "She did what she could with what she had. She left a trail. My daughter made a sound that was somewhere between a short laugh and something else entirely. That sounds exactly like her, she said. It does, I agreed. The legal process moved slowly, the way serious cases do. The woman who ran the unlicensed firm reached a cooperation agreement with the Commonwealth's attorney in exchange for reduced exposure. My wife rejected the first plea offer, then the second. She hired a new attorney after Craig Beale withdrew. The new attorney was more aggressive and had considerably less to work with. The transaction records were thorough. The medical timeline was documented precisely. My mother-in-law's letter and the recordings were admitted without significant challenge. My wife accepted a plea 8 months after the mediation. The charges fell under Virginia's financial exploitation of an incapacitated adult statute, a felony. The sentence, given the absence of prior criminal history, included suspended incarceration, 5 years of supervised probation, and full restitution with interest. To satisfy the restitution, several assets were liquidated, including an investment account opened in her own name, and a piece of property she had told me was being considered as a joint retirement purchase. I had not questioned it. I had been doing what I always did inside that marriage, observing things I had not yet named, in the name of a peace that was not, in the end, actually peace. I was wrong to stay as quiet as I did for as long as I did. Not wrong to be careful. Wrong to let careful become its own kind of silence, one that let things continue that I could have interrupted sooner. I've had a lot of time to sit with that distinction. My son came to see me in early winter. He didn't call ahead. He appeared on a Saturday morning with a box under one arm. Things he'd found when helping clear his mother's house before the property settlement. Inside were objects that had belonged to my mother-in-law. A small framed photograph of her and me at my daughter's college graduation that I hadn't known existed, the emerald brooch, and a handwritten recipe card for the apple cake she made every Thanksgiving written in her careful librarian's cursive with annotations in the margins about what to adjust depending on the variety of apple. He set the box on the kitchen table and looked at it instead of me. "I owe you an apology," he said. "You don't," I told him. "I assumed things about you," he said, "for a long time, because she said to." I looked at my son, who was 28 years old, and learning something that most people learn too late or not at all, that the person who speaks with the most certainty about another person's character is not always the most reliable narrator of it. "You came here," I said. "That's enough." He stayed most of the afternoon. We didn't resolve everything. Some things don't resolve in an afternoon. Some things rebuild slowly, the way soil does after a hard season, below the surface first before anything visible changes. My daughter flew in the following spring with her partner, whom I had met once at a holiday gathering several years earlier. We ate dinner at the kitchen table and talked for a long time about things that had nothing to do with any of this. Her work, a road trip she was planning along the coast, what I had been reading. Before she left, she hugged me in the doorway for a moment longer than usual. "I should have called more," she said. "So should I told her. She nodded. That was enough for now. My mother-in-law's house in Galax sold that summer. On the afternoon before closing, I drove down one last time and walked through the empty rooms. The house had been staged and cleaned, the shelves where she kept her books bare, the kitchen smelling of fresh paint instead of the particular mix of cedar and old paper that had been her signature for as long as I had known her. I stood in the living room for a while. Then I took her letter from my jacket pocket. I had carried it with me since the day I sat in that parking lot in Galax, and stood at the window where she used to do her Sunday bookkeeping, a cup of tea beside her, a yellow notepad open on the sill. I read her last line one more time. "You always noticed what the rest of them were too busy to see. I need you to look now." I folded the letter carefully and put it back in my pocket. Then I walked out onto the porch and stood in the summer air and let myself feel what I had been too careful to feel for the better part of 2 years. Not triumph, not exactly relief. Something quieter than either of those. The particular satisfaction of having used what you know in the only way you know how to use it, without announcement, without drama, because someone who trusted you asked you to look, and you looked. The final documents arrived from the court clerk's office 4 months later. Estate of Evelyn Nadine Pryor closed. Restitution satisfied in full. I set the envelope on the kitchen table beside a cup of coffee that had gone slightly cold and looked at it for a while without picking it up. Outside, a neighbor's sprinkler ran in slow arcs across the yard. A car passed on the street and kept going. Ordinary sounds returning the way ordinary sounds always do, eventually when the wrong kind of quiet finally lifts. My mother-in-law used to say that the most honest record of a person is not what they claim, but what they sign, what they save, and what they choose to send. She said it once, over apple cake in the way she said most things worth saying, plainly without repeating herself, on the quiet assumption that you had been paying attention. She was right. And she knew when she addressed that envelope and brought it to the post office 6 days before she died that I had been. I got up from the table slowly, the way you do at 61 when the morning has its own ideas about pace. I carried my coffee to the window and stood there in the light for a while, watching nothing in particular, in no hurry to be anywhere else. If you've ever been written off by someone who mistook your patience for absence, tell me where you're listening from. Tell me what time it is there. These are the stories worth keeping, and I have more of them.